Anthony Di Mascio de l'Université Bishops, qui est professeur à la Faculté des sciences de l'éducation. Ses travaux portent sur les origines et l'évolution de la scolarisation de masse et mettent en lumière le rôle des diverses forces sociales, politiques et économiques dans l'évolution des systèmes scolaires modernes. Il s'intéresse tout particulièrement à l'intersection de l'histoire et des politiques éducationnelles et aux façons dont ce champ d'études peut contribuer à l'élaboration de politiques publiques éclairées, avec un article ou un papier qui s'intitule « De l'article 93 à l'article 23, perception publique des changements constitutionnels en lien avec l'éducation des minorités anglophones au Québec dans les années 90. »
See Stephanie, let's see who. So I will get right to it. In 1997, a constitutional amendment, as you all know, was granted that made paragraphs 1 to 4 of Section 93 of the Constitution, which had provided legal protection for Catholic and Protestant school systems, no longer applicable to the province of Quebec. Part of the argument that forged the end of denominational schooling was that minority school rights for English speakers would be protected by Section 23, discussing of the Charter, and that the existence of a separate system was thus not under threat. Protestant schooling in Quebec, however, had, to that point, rock-solid constitutional protections under Section 93 that the courts had affirmed for over a century. The solidity of Section 23 of the Charter, on the other hand, was not as clear. The aim of this study is to assess the extent to which the English-speaking community understood the shift in constitutional protections that would thereafter protect minority schooling in the province. To what extent did they consider the balance of rights that would be lost and those that would be gained? It does this primarily through a reading of the press in 1990s Quebec. My research assistant and I have been gathering newspaper articles, editorials, letters to the editor, that sort of stuff, juxtaposing it with legislative developments and the political discourse in order to assess this. I'll go through some of that, and I'll end by tying the historical record of the 1990s to the recent court ruling surrounding Bill 40 in Quebec. And if you look at the Court of Appeals recent ruling, they have a lengthy section there on Section 93, signifying its importance there. In many ways, we have, in the last few years, essentially picked up on a debate that was heated, but never fully resolved in the 1990s. I'll start with a brief overview of what Section 93 and 23 are, although I realize I'm preaching to choir here, and why they're important. From an historical perspective, one thing that is extremely important about Sections 93 and 23 is that we're talking about the relationship between the federal government and the provinces as it pertains to education. Section 93, when it was enacted as part of the Constitution in 1867, provided guarantees to Protestant and Catholic minorities that had already been operating public schools in their colony at the time of union to maintain those separate public schools. If the provinces, who otherwise had legal jurisdiction over schooling, did not respect this, then it granted minorities the right to make appeals at the federal level, and even granted the federal parliament the right to enact remedial legislation should a provincial legislature refuse to comply with any decision arising from an appeal. One of the enduring myths in educational discourse, and perhaps there's a better word than myths to use there, but one of the enduring myths in educational discourse in Canada is that there is an impermeable line of demarcation between jurisdictions of power, and that the federal government is not involved in education whatsoever. But the federal government has had a role to play in education. It is, ironically, perhaps, the guardian of Canada's systems of publicly funded separate schooling, as are the courts. And when challenges were brought before the courts after 1867 concerning Section 93, the courts have made it clear that Section 93 was, as one historian has called it, an immovable force. Right? Ask anyone in Ontario trying to get rid of Catholic schools, it's virtually impossible to do so through the courts. reaffirmed that over and over. And you can only do it politically, essentially. In Quebec, this force protected Protestant school boards, the de facto English school boards, shielding them from any challenges against their legitimacy or from provincial governments who wish to eliminate or restructure them. Section 93 could not be ignored legally. It could only be removed politically through a constitutional amendment involving both the provincial and federal governments. Now, Section 23 of the Charter of Rights and Freedoms, enacted in 1982, essentially says, as you all know, that Canadians have the right to have their children receive primary and secondary school instruction in their own first language, right? That's Section 23(1)(a). In the language they went to school, Section 23(1)(b), or in the language their child's sibling went or is going to school, Section 23(2). Section 23 has important limits, though. Right, first, Section 23(1)(a) does not apply in Quebec until the National Assembly of Quebec allows it to, which it is not. Moreover, and very importantly, Section 23(3) requires that there be sufficient numbers of children to warrant the provision of minority language instruction. The Charter didn't define what constitutes a sufficient number, leaving its application open to the courts and their interpretations. There have been many cases. The most famous is obviously Mascio versus Alberta. In this case, the Supreme Court affirmed that parents exercise a degree of control over minority language education by establishing a sliding scale approach. In practice, this means that control over the level of minority language education provided should be proportionate to the number of children requiring it. So, for example, Section 23 can be triggered at a low number, where a local school board would have to offer, say, a minority language program within the local public school, or as numbers get higher, then more management over the schools themselves may be warranted, such as full community management over facilities, and at the higher end of the scale, even a publicly funded school board system under community control could be warranted. Again, this is the court's interpretation, and there is no specific language in the charter that states this. Okay, so why did the Quebec English-speaking community of 1990s willingly, or perhaps it was begrudgingly, trade in essentially rock-solid protections to Protestant minority rights under Section 93 for protections to English language minority rights under Section 23? In order to understand the history of the deconfessionalization of Quebec education, we need to go back, as we do with many or most contemporary educational matters, to the Quiet Revolution. Historically, we have a pretty good understanding of the basic series of events that led from the 1960s, when the Royal Commission of Inquiry on Education, the Perron Commission, recommended deconfessionalization, to the 1997 constitutional amendment, which finally achieved that recommendation. Surprisingly, though, there's very little written concerning what people thought about that change. Briefly, the 1960s and 70s can be characterized as decades of resistance against efforts to deconfessionalize the system. This isn't exactly a historiographical revelation. Much work has been done on this period. I won't get into all of the court cases and discussions in this short presentation, but it should be noted that the courts made it clear to reaffirm in the 1970s, because the Privy Council had done so decades earlier, that when it comes to language of instruction, the province could indeed impose restrictions. In other words, religious minorities, as defined by the Constitution, were protected, but linguistic minorities were not. Protestant boards and the English-speaking community that used them as their de facto English system seem to have been acutely aware of the legal protections they had, and so more or less resisted efforts at structural changes to their boards these years. The protection of Protestant school boards to manage their own affairs in no small way symbolized the English-speaking community's rights to manage their own schools, even if that right wasn't necessarily guaranteed. But that arrangement wasn't perfect, and we also see in these years that the community wasn't entirely beholden to the religious protection Section 93 offered it, if they could have clear protections for language that better reflected their rights and identity as linguistic minorities. Both the Montreal Gazette and organizations like Alliance Quebec expressed support for deconfessionalization. The question was how to go about doing it, because the protection of Section 93 was very difficult to give up. Having learned from the legal challenges of the previous 2 decades, Bill 107 was introduced in 1988 with the aim to create linguistic school boards, but it maintained denominational school boards as it was required to do so by law. By the 1990s, however, the PQ governments of Jacques Parizeau and Lucien Bouchard wanted to end the issue once and for all. Their massive grassroots consultation process concerning the state of education in Quebec, under the direction of the Commission of the Estates General on Education, issued its final report in 1996, recommending 10 priority actions, including the creation of a complete non-denominational, linguistically divided school system. To make this happen, the province set up to amend the Constitution and make Section 93 inapplicable in Quebec. By then, even leaders of some Protestant denominations who had raised concerns at the Estates General tended to focus less on religion and more on ensuring protections for the continuing vitality of Quebec's Anglophone communities. The emergence of Section 23 in the 1980s had changed the public discourse concerning Section 93 and deconfessionalization. But in its dust, was Section 23 of the Charter really enough to protect the English language schooling in Quebec? Okay, so we've been going through this, and we can extract 2 types of voices, I think, in the 1990s that begin to answer this question. One was more of a broader, general public voice, as I'll call it, which supported a linguistically divided system in so much as they perceived it to be guaranteed. Discourse was not very technical and tended to make emotional, not legal appeals to concepts such as rights and fairness, and was often coupled, with unsubstantiated should statements, right? This is what we should do. This is the direction we should go. The other voice was that of a more specialized intelligentsia of sorts, I'll call it. These were English-speaking community leaders or elites who engaged with the debate emotionally, of course, but instead of focusing on nebulous appeals to perceived rights and fairness, they engaged in a more technical discourse about these concepts in relation to law. This intelligentsia had a lot more to say directly about Section 23, and they made a concerted effort to speak to the public through the press and attempted to even shape that discourse. So, as an example of the general public, as I call it, emotionally based appeals, one person writing to the Montreal Gazette conceded that while in the end there could be no definitive guarantee for the long-term existence of English school boards, he nonetheless supported the creation of linguistic school boards and the elimination of Section 93 in Quebec, believing that court rulings surrounding Section 23, alluding to the Mahé decision, I assume, gave the English-speaking community enough guarantees. He found debate over the repeal of Section 93 at the time to be an unnecessary distraction, he called it in fact. What political leaders should do, he believed, was enshrine linguistic education rights in the Quebec Charter of Rights and specify in the Education Act the right of the English community to manage and control its own schools. He did not suggest, however, why the government would do so. An editorial in the Montreal Gazette in June 1996 also believed the constitutional amendment to get English schools under English school boards controlled by the English community and put an end to Section 93 was acceptable and reflected the community's constitutional right to control its own schools. Again, alluding to the Mahé case. It went so far as to suggest there was a consensus on this matter. However, a deeper reading of the public discourse suggests that faith in Section 23 replacing Section 93 was not shared by the entire English community. Some of the leading voices of the English-speaking intelligentsia that I spoke of did not believe Section 23 was enough at all, in fact, and rang the alarm. In an opinion piece that appeared in the Montreal Gazette in 1997 with the apt title, "The Charter is Not Enough," for example, lawyer and professor Julius Gray, who of course here today, summed up the issue succinctly. Among other concerns surrounding the limits of Section 23, Quebec has consistently argued in courts for the narrowest possible interpretation of Section 23, he said, and for the broadest application of Section 1 of the Charter, which permits exceptions to charter rights. The autonomy to given to minority schools under section 23 is, quote, vague and uncertain. It also varies with the number of students. Why then replace the confessional guarantees in section 93, which, again, quote, ensure the existence of autonomous elected boards that can better stand up to government pressure, with the uncertainty of section 23. There doesn't appear to be any definitive answer the community could come up with to this question. Yet its school boards were about to lose section 93's rock solid protection. The president of Alliance Quebec echoed these concerns while he and Alliance Quebec supported the creation of linguistic school boards. Hamilton agreed that section 23 of the charter was not enough. For one, the charter was not recognized by the Quebec National Assembly. How could minority language rights be guaranteed through an article of a charter that the provincial government itself would not formally recognize? Furthermore, he noted, the wording with respect to English-speaking Quebecers and their educational rights is troublesome. Does it enlarge the Bill 101 definition of who is an Anglo, he asked, or does it risk providing momentum for a terribly worrisome effort afoot within the P2 cabinet to further restrict that definition? There were too many legal and technical unknowns. Many of the English-speaking elite insisted that the surest way forward was not a complete repeal of section 93, but new language that would explicitly extend to linguistic minorities the rights that religious minorities had enjoyed for well over a century. Section 23 offers greater protection, Hamilton said, because in the past, Protestant has generally meant English. The goal of linguistic boards is valid, but do we want to give something up, he asked. Do we want to give up the legal jurisprudence, which has interpreted Article 93 this way? Victor Goldblum, who at the time was the Federal Official Languages Commissioner, added to the voices calling for new Section 93 language, stating that section of the 23 of the Charter was, quote, not nearly as specific as Section 93. Premier Lucien Bouchard, however, disagreed. Section 23, he argued, provided enough protection to the English-speaking community, and the community itself should not be afforded any greater guarantees than the Francophone minority outside of Quebec. It was time to simply move forward with the removal of Section 93's application to the province of Quebec. Province was determined to do so. Stéphanie Dion, who was the federal minister overseeing this file, suggested in February 1997 that the voice of the English-speaking community in Quebec would ultimately determine if Section 93 were repealed. What we need first to see, he said, is if there is a consensus. It is the beginning of a very difficult debate, and it is not time now to say there is or is not a consensus. Time came rather quickly, however, as less than a year later, the amendment to repeal Section 93 was agreed to in both the National Assembly and the House of Commons. The historical evidence that there was a consensus to do so, however, remains inconclusive at best. Nonetheless, Section 93 was made no longer applicable to Quebec. Moving forward, there would be no more Section 93, no more appeals to the federal government, and no real political involvement at the federal level should the educational rights of minorities be affected by the provincial government. Any challenges concerning English school boards in Quebec would lead to a purely legal battle between the people and its provincial government, with the courts ultimately determining how to move forward on any systemic changes proposed by that level of government. The debate in the press died after this. Willingly or begrudgingly, Section 93 of the Constitution would no longer protect minority public school boards in Quebec. For about 20 years after the passing of the constitutional amendment, neither the PQ nor the Liberal governments of the first 2 decades of the 21st century attempted to threaten the rights or autonomy accorded to English school boards. They operated, for all intents and purposes, as the confessional boards they had replaced. Then on October 1st, 2019, the provincial CAQ government awakened the debate that had been lying dormant for 2 decades when it introduced Bill 40, Bill 40. The service centers that Bill 40 aimed to replace the school boards with would have less authority, virtually no autonomy, and fewer democratic powers. The bill was met with immediate condemnation and, unsurprisingly, legal challenges concerning the community's management rights were launched. suddenly people were talking about section 23 again and whether it protected school boards. And here we are today. I'll end not by recapping what I've said, but with some speculative questions concerning the most recent rulings on Bill 40. The Superior Court's 2023 ruling in favor of the English-speaking community and the Appeal Court's affirmation of that ruling in 2025, last month, have begun to provide some answers regarding just what type of certainty Section 23 provides. That is, it seems like Section 23 may be proving to offer some rock-solid protections of its own, as Section 93 once did, when it comes to shielding English school boards in Quebec from the infringement of the provincial government. At least it does within the current context. There remain some concerns and some limits and challenges that linger, I think. For one, the big question, I think, the question of where the numbers warrant. Right now, the numbers warrant, but will they always? What about numbers in the regions? Should those communities be concerned? What threats to future case-by-case interpretations of Section 23, 23, excuse me, was designed to function pose? Will the Supreme Court uphold recent rulings on Bill 40? Will their interpretations differ? Okay, so very quickly, if you give me 10 more seconds here. The extent to which English school boards in Quebec will have constitutional protection and the extent to which provincial governments can inflict harm on them may be a matter for the courts to determine for some time. If nothing else, we're reminded just how early we are in the history of Section 23 still. Section 93 of the 1867 Constitution Act, we should remember, took years to see clearly, decades really, but the legal protection it gave to minority school boards was rock solid. Will we ever be able to say that about Section 23? Is the debate of the 1990s resolved? Okay.